Generally, to employ this sort of strategy, I'm representing a third party fund, investment manager, or solo investor who is looking out and saying, okay, I'd like to pursue a strategy in which I acquire this type of asset, this type of real estate asset. And they'll be, they'll have their team look through the secondary loan market. And that market is being populated by usually bank lenders who don't have the stomach for certain risk. And they don't want to go through foreclosure proceedings because they're expensive and they really aren't in the business of, running real estate. They're in the business of getting paid. So if they view that this loan may be non-performing, and rather than enforcing those covenants, some other types of lenders will, but generally banks won't. They'll say, okay, I don't want to deal with foreclosure. Let's put this on the market, see if we can recoup some amount of value for it. It's going to be less than what we put out, but if we could recoup some now, I don't have to worry about it later. I have no out-of-pocket expenses.
Welcome to CRE Radio for influential commercial real estate professionals who work with investors, buyers, and sellers of commercial real estate coast to coast. Whether you're an investor, broker, lender, property manager, attorney, or accountant, we're here to learn from the experts.
Welcome to Commercial Real Estate Pro Network's CRE Radio. Thanks for joining us. My name is J. Darren Gross. This is the podcast focused on commercial real estate investment and risk management strategies. Weekly, we have conversations with commercial real estate investors and professionals who provide their experience and insight to help you grow your real estate portfolio. Today's interview is sponsored by Building Insurance and Risk. When you invest in real estate, it pays to work with a real estate investor protection specialist to protect yourself and your investment from catastrophic loss. The experts at Building Insurance and Risk focus on real estate investor protection. They provide you with multiple insurance coverage offers and a side-by-side coverage comparison. To learn more, go to buildinginsuranceRisk.com. Today, my guest is Chris Zona. Chris Zona is a partner at Mandelbaum Barrett PC in New York and a trial attorney specializing in complex commercial litigation. And in just a minute, we're going to speak with Chris Zona about turning conflict into capital, litigation as a real estate investment tool. But first, a quick reminder, if you like our show, CRE Radio, there are a couple things you can do to help us out. You can like, share, and subscribe. And as always, we encourage you to leave a comment. We love to hear from our listeners. Also, if you want to see how handsome our guests are, be sure to check out our YouTube channel. You can find us on YouTube at Commercial Real Estate Pro Network. And while you're there, please subscribe. With that, I want to welcome my guest, Chris Zona. Welcome to CRE Radio.
Thanks so much for having me. It's exciting to be on and to discuss kind of turning a series I recently did called Turning Conflict into Capital on how to use litigation as a means to unlock value for investors and investment fund managers.
Yeah, well, I'm excited to have you. But before we get started, if you could take just a minute to share with the listeners a little bit about your background.
Sure. So I'm a lawyer practicing mostly in New York City. I also practice in New Jersey, Connecticut, and federal courts around the country. I'm with Mandelbaum Barrett, which is a regional law firm with outstanding reach. I've previously been at large law firms that have had a national reach, and kind of throughout my career really have focused on litigation. Prior to that, I worked in the criminal sector as both a prosecutor as well as a defense attorney for a period of time. But since coming into the private sector, one of the aspects that's really interested me is how the idea of litigation has changed over time and moved from a cost center to potentially being an affirmative value creation tool. But yeah, mostly I do trial work in New York and New Jersey for medium size and larger clients with a range of industries. I don't really have a niche besides the fact that I go to trial and I try to get the best value for my clients.
Got it. Well, in real estate and law regarding real estate, is what you do, is it more, well, no, I don't say it was what you do, but I guess there's a couple of directions that I always think of. I mean, the first being like a lease or a contract, spelling out what parties are expected to do, and then also consequences or the duties if these things are not met. Is that a fair uh, presentation as far as, I mean, just as a starting point with how
Sure.
things
Sure.
uh,
So I think that, and I think there are a couple aspects that I'm sure your listeners, as well as investors or fund managers who work in the commercial real estate, utilize attorneys for. I think the most classic use is exactly as you're describing. Most attorneys in the commercial real estate game are helping clients with lease restrictions, lease covenants, writing them on the side of the lessee, or I guess approving them on the side of the lessee, writing them as on the side of the lessor, but also helping with securitization, security agreements, mortgages, liens. Really, where I've focused, well, let me start with that's kind of the classic view of where lawyers fit. And the majority of your listeners probably have used lawyers for that. Title searches, all the way down to reviewing those documents. Kind of where I fit in is to actually assist in uncovering assets that may not be otherwise available. Utilizing litigation to potentially get into an asset, get into an investment through the secondary market, through foreclosure proceedings, through potential assertion of mezzanine debt rights, like UCC Article 9, and actually helping to enter an asset as an investment and either take it over to then sell off through auction, or to actually take over and utilize the capital appreciation asset.
got it. So the means that you enter or is through finding these other opportunities or perhaps assets or like I guess you mentioned foreclosure or other things where, and I'm assuming that there's some, I don't say an injury, but somebody's failed to fulfill the contract. Is that kind of the genesis where you would become part of this?
Sure. So, to the extent that there is a secondary loan market, right? Like we all know that, if you have a mortgage as a human, as a person kind of around, there's secondary loan market. Sometimes you'll get a notice saying that your loan, which you took through Bank X, has been purchased by Bank Y. And you'll get a notice, and it means that you're going to pay your money to a different name, but nothing else changes. Well, that means that your bank, who you initially took the mortgage from, sold either your mortgage solo or a bucket of mortgages as part of an acquisition to another company who purchases it for either par value, a premium, or potentially a discount. The entrance point really that I like to talk to clients about is through the secondary loan market. There are a number of third parties that offer subscription services. There are some government functions that will define loans either as kind of buckets or solos that are either performing loans, so everybody's up to date and potentially they're being sold because the bank just doesn't want that risk matrix, or NPLs, non-performing loans. And generally an NPL is that there's some sort of non-payment in the 60 to 90-day range, and there is a risk associated with that the lender no longer wants to stomach on their own. So they're putting that loan out to the market to say, hey, purchase this loan at usually a discount. And that's where the entrance is attractive for a lot of investors who are kind of viewing litigation as an asset creation. And you say you buy a loan at 65% of what the par value of the loan is, and now you become the lender. And you assume all of the rights as well as the obligations, but a lot of the rights to assert whatever's in your security agreements against the tenants, against the lendee, against whoever's in the property. And that's usually the entrance point. There's also means by which through mezzanine debt, where if you find that an entity that may be holding the loan, so rather than it being real property, it's actually the entity holding the loan. The entity may be non-performing, it may be being mismanaged. And then that would be through UCC Article 9, which is a little bit of a different procedure than going through like foreclosure, which would be generally the legal way, or breach of the security agreement, if that's how it is. But it would be through UCC Article 9 enforcement, which is non-judicial in the formal sense, but still pretty much litigation to assert your rights and take control of the entity, which then owns the property. So that's really the entrance point for most investors or fund managers who are utilizing this sort of approach.
Got it. So the client in your case would be either a lender or a somebody that like or I shouldn't say lender. The lender is the one looking to I guess it depends on who you are because there's multiple parties and I was just trying like in my mind understand, but the lender who's not received payment is looking to sell or be made whole, and would you then be representing the party approaching the original lender to purchase that loan at a discount, or would you potentially be representing the lender that is looking to sell the loan?
So generally, I could represent anyone. It really depends on who your lender is, right? Generally, to employ this sort of strategy, I'm representing a third party fund, investment manager, or solo investor who is looking out and saying, okay, I'd like to pursue a strategy in which I acquire this type of asset, this type of real estate asset. And they'll have their team look through the secondary loan market, and that market is being populated by usually bank lenders who don't have the stomach for certain risk, and they don't want to go through foreclosure proceedings because they're expensive, and they really aren't in the business of running real estate. They're in the business of getting paid. So if they view that this loan may be non-performing, and rather than enforcing those covenants, some other types of lenders will, but generally banks won't. They'll say, okay, I don't want to deal with foreclosure. Let's put this on the market, see if we can recoup some amount of value for it. It's going to be less than what we put out, but if we could recoup some now, I don't have to worry about it later. I have no out-of-pocket expenses. I'm helping that third-party purchaser who's coming in and is going to step into the shoes of the lender. And then over here on your other side, you have the individual who actually holds title to the property at that time, and they would be, whatever position they're in, but they are the note holder at the time. And then I'm going to become the lien holder.
Got it. So, as far as the I guess your clients, are they typically like a pool of investors or an individual investor that's recognized that the climate is ripe? I mean, there's question. I don't know if there's a question. I think there's clearly there's some asset classes right now that are probably prime for this. That do the investors identify and engage your services like before they identify a property, or is it once they've identified one that you'd be brought in?
Kind of a mix of both. A lot of times, and especially nowadays, what I've been trying to do is talk to a wider variety of fund managers or investors or investor groups about employing this strategy. So just kind of taking a step back, historically, litigation has always been a cost center, right? We all view litigation usually as either I've been hurt and I need to be made whole, or I want something and therefore I'm going to put out capital to affirmatively go get it. Either way, money's coming out of my pocket for delayed gratification with the hope that later I'm going to get the money back, hopefully with a premium. If it's defensive litigation, then it's that I'm not going to have to pay X amount of dollars. That's the historical view. You talk to businesses. When I was in-house, litigation is always a cost center. Over the past 2 or 3 decades, especially in America, you've seen the rise of litigation finance, litigation funding, and that's kind of changed the view of how litigation can be used as an asset, especially a non-correlated asset with the ups and downs in the market. Litigation's not tied to it, right? Oil could be up. Microsoft could have great earnings or bad earnings. If we get a good recovery on litigation that's been funded, then there could be a return for investors in that fund. More recently, and this has probably been a strategy that's gone on for a longer time, but I think more recently, and especially with the way the real estate market is in the past probably 2 years or 3 years, you would know better. I'm not a real estate expert, but within the last few years, there's been a lot more fluctuation. Funds have started to employ a means by which they aggressively are pursuing either non-performing loans in certain markets or in certain asset classes, where they will then buy the loan, assert their rights. Either, generally, I would say the majority of them will assert those rights to take over and sell that property at a premium for either their investors or for a solo investor. Usually it's not a single person, just because the money we're talking about, if you're especially in New York City, you're talking about tens of millions of dollars of risk that you're putting on the table and probably spending to purchase a secondary loan, even at a discount. But it's usually an investment manager who's pursuing that strategy. And the one thing that I've noticed is that it is very strategy driven. And the reason that I really wrote this part of the series that I wrote about real estate investing is because I've seen that even when I've talked to fund managers about it, a lot of them will retort to me, we don't really use that strategy. Our strategy is capital appreciation. We want to buy potentially distressed properties, but then develop them and create long-term appreciation with likely income along the way. And what I've tried to stress, and one of the reasons that I've kind of gone this direction, is that there is a hybrid in which the litigation posture can actually assist investors to get into assets and properties that aren't otherwise available. And with a little more understanding and foresight into how litigation may be helpful and useful, investors can actually access assets they wouldn't otherwise be able to access because they either just don't know or the asset's not available. So really, that's where I've been pushing clients and potential clients to look at litigation as more than just your entire fund or your entire investment strategy has to be this, versus, hey, if your investment strategy is X, I can still help you because I can assist you into getting into assets. Not every asset, and maybe only a select few, but it may also unlock an asset that you potentially can get at a substantial discount, or an asset class or a market that you couldn't otherwise enter because of capital restrictions. You don't have the raise, you don't have the investors.
So I'm curious because as you're speaking, I'm having some thoughts about some recent events, recent transactions I've seen here just locally. And from a standpoint of having access to a property that previously may not have been available, but just due to the market conditions, you've got a non-performing note, you've got a lender that's would love to get market value, they'd love to get what they were expecting, but that's not going to happen. Is there? Because I'm just trying to think, if it seems like a lot of times, or not a lot of times, the one I'm thinking of it specifically, there must have been some dire desperation based on the numbers. I mean, this property sold for like 12% of what it sold for, just maybe pre-pandemic. And that was, it's an office building, fully occupied, pre-pandemic. Pandemic hits, everybody goes home, nobody's in the building, and it's sold for just a song, but it's an empty building. And what I'm curious about is, and I don't know all the particulars on how the negotiation occurred, but in your model here, where you're assisting investors, or funds or whatever to try and acquire these, are the signs of a situation where there's definitely some red on the balance sheet? Is it easy to identify? Is it?
So
I mean,
it's It's probably not hard to identify places that are in trouble. It is hard to identify places that are going to unlock a value that your investors or you personally, as the investor, are going to want to kind of carry the risk, right? Because there is risk. If you purchase a note and it continues to non-perform, or if you try to assert in certain rights and they don't necessarily come out how you want, or it all works and you just can't turn the capital around to make your return, then it's like any other investment. It could go south, or it could go flat, or it could not, return what you want. However, what we saw in COVID a lot, right? We saw building owners who became cash strapped, and obviously there were legal pitfalls for them, as well as legal assistance with COVID. But in those sorts of situations where you're depending on rental income for your operating income, and that rental income all of a sudden stops flowing in, that's one opportunity that investors are able to look around and say, okay, in this sort of market, and right now I think we have there's similar market conditions with the interest rates, knowing that certain types of industries or certain note holders may need to refinance, and they just can't at a certain interest rate, so they become cash strapped. Conversely, the bank is desperate to get it off their balance sheets because they see where it's going. So a lot of it, identifying the right quote unquote investment is very much something that is a combined due diligence project. While there are pure third party vendors and services to enter secondary loans, a lot of times it comes from relationships with banks or relationships with private lenders or private credit institutions, in which you kind of are clued in on, how they operate. So then what's going to be in the lease or in the note or in the mortgage or security agreement or whatever you're going to want to enforce. But the situation you're talking about, I mean, if you can get into a building for 12% and become the controlling owner of it, whatever your long-term horizon is, you're in a building that has value, right? The land itself has value. You become the control of it, even if you want to turn around, if you want to change it. Recently in New York, there have been a number of developments in which, substantial buckets of these mortgages have been purchased by certain entities that purely engage in this sort of mortgage purchase, auction, and turnaround strategy. And they've been very successful. They've returned huge dollars on it, because once you buy that mortgage, you buy the mortgage, usually you're going to be able to find some sort of covenant within it which has been broken or is being violated. You can then sue to enforce that. And whether or not you go through full foreclosure proceedings, or you could work something out where there's a title transfer or a negotiated transfer of some sort, if you're going to auction, you could then credit bid it because you own the full note. If you're talking about these high-priced markets, very few people are going to want to pay whatever that note is, especially if there are outstanding debts on it. You're usually talking about huge interest rates for non-performing on payments that all need to be made whole for that lender to release the property. So you credit bid on it. You don't come out more on pocket. And then you start to either run the building, or you have some sort of capital investment into the building to then turn around and sell it. And that's generally what you see. And that's, recent, I think I'd say within the past year, in New York City, you've seen a number of portfolios of loans being purchased by certain entities that kind of engage in this specifically.
So let me ask you, I understand basically the concept you're trying to buy the note. What is it more attractive to the lender that's got the non-performing note to sell the note, or is that more like a secondary option if they can't foreclose and sell the property? Is there, I mean, because it seems like it would be expeditious to sell the note as opposed to going through foreclosure and then having to sell the property.
Absolutely. I would say most lenders are not going to want to invest the capital in trying to foreclose, being tied up in court, and then just hoping that they can then auction the property for a gain, right? Because even if most of these lenders aren't in the business of owning real estate. So even if they foreclose and they take possession of the property, they're still out their money on the note, and they have to then hope that they can auction it at enough to get a return. Conversely, you go to the secondary market and you approach either as a solo, but a lot of times you'll see kind of a bucket of these being pooled together if you have an entity or a person that owns a number of notes with that particular lender. And you can kind of offload all of that risk, maybe at 60 or 70% today, nothing out of pocket. You now have that money. If you're a smaller lending institution, you have that cash back in hand to actually go and pursue other things. If you're a larger institution, it's a little less, which is why you'll see like large institutions will probably give a little more leeway. But sometimes, depending on the nature and depending on their relationship with the lendee, they may know where this is going. Hey, we know that this is going to go south. Let's get rid of it now. And if we can get 70% of par, if we get 60% of par today, we're going to get 50 next year because it doesn't look like we're going to have a performance on this. And that's generally what I see. I don't see banks that really love litigating. They view it as a cost center because their strategy is not to own real estate, which is why kind of, as an investor or an investment fund, if your strategy is to own real estate, or if your strategy is to develop real estate or turn around real estate, kind of any of those strategies, this does lend itself, in my belief, it lends itself as a creative option to access an asset class at a discount that you might not otherwise have.
Yeah. So from the acquiring party that acquires the note, is there, I'm trying to think, what are the advantages to acquiring the note versus acquiring the property? Because, I mean, obviously, if you acquire the note, at least you're is it basically control and also the speed and that now you have control as opposed to going through a whole market bid kind of thing?
Yeah, absolutely. It really is the discount, and it's the speed with which you can do it. If you as a potential purchaser approach the person who's in debt, that person's going to want to cover their full mortgage on the sale. Versus you approach the bank, that really there are extremely limited rights that the lendee has for most of these notes for them to be sold. So why not approach the bank, buy up the mortgage at a discount, and then usually you have pretty good covenants and obligations within that note to be able to enforce. You could have loan service cover ratio requirements. You can have, if there's a guarantee, there could be certain liquidity or net asset requirements for the guarantor, which would be the person holding the note, that you could then turn around and enforce pretty quickly and get a default. Then jurisdictionally, where you want to go, how you want to do it, those are all things that you have to work out and you have to understand before you really employ this strategy. And that's part of the diligence process, right? There are places that it's really good to do this in certain states. You can do a non-judicial foreclosure that goes very quickly. Texas comes to mind. There are states where it's hard. New York, it's notoriously slow. There are more, it's more litigious, but you're talking about huge returns, right? You're talking about, if you're trying to get into a multi-unit building in Manhattan, that building could go for $30-40 million on the open market. And if you can access that on, a fraction of whatever the mortgage is, that you could potentially return, 30, 40, 50% on a sale of that.
I'm curious, how often have you found your client, have they tried to acquire the property directly from the party that's on title that's perhaps not performing, and then instead they go and they approach the bank and buy the loan?
It depends on the strategy being employed. Generally, I would say that if you're going to employ this strategy, you're going straight to the secondary market. You're always going, I won't say always, but almost always going to get a better deal. It also a little bit depends on what your end state wants to be. If you're in a capital appreciation or you're just trying to get into properties that are potentially in distress, it may make sense to negotiate something out. If it's a tenant owner and you want to do something like a lease back where you're buying the property and then leasing it back to them, or keeping them as a tenant and they just don't want to own the property, then likely it makes more sense to go through them because you want to continue to have a good relationship. But those are, in my kind of estimation, more one-offs. If you're doing this as a true strategy, then it really makes more sense to develop your relationship with whatever lender or group of lending institutions so that you can have an understanding of what that secondary loan market is, and then really just drill down on your due diligence, right? If this is not your primary strategy in your investing, whether it's a portfolio or it's a one-off, then I don't think that it is probably the most attractive because it is a little bit complex and there is a risk matrix and you have to have a stomach for that risk. But at the same time, I think it's silly not to at least consider it because you may just not be able to afford or have to do an additional capital raise, or you yourself as an investor don't have the money to just buy it on the open market and to approach the individual and make a good enough deal. Whereas if you can get in at a discount, whatever level that is, and whatever end state you want to be in, then I think that it makes sense to at least pursue the option, see what it looks like, see how it compares to the other asset classes and the other deals that you're trying to make, and then mix it in, right? If you have a portfolio of 10 or 15 properties, I personally think it makes sense to at least see if one or two of those properties can't be acquired through, more aggressive strategy, I call it, or a more hostile strategy, because you may be able to unlock an asset class that you just otherwise can't, or go to a market that you otherwise aren't in.
Yeah, no, it's interesting as you're talking, I'm starting to see this a little more clearly for what it is, and just having that access to the secondary lender market there, and the ability to negotiate at a discount and without having to deal with the seller or the the property directly. Now, my curiosity. So, I guess well, it shouldn't be a curiosity. The play is, while it's an investment, it's no longer a an equity play. It's more of a debt play, is it not? I mean,
Yeah, it's more of a distressed play.
yeah, yeah. No,
Now, there are ways that you could flip it, right? I mean, you could flip
right.
it into an equity play if you don't want to pursue full control. If you want to do a mezz debt play, then you're going to go more into, control, potentially majority ownership in the entity that's holding the property. So you're staying completely away from the property itself. But yeah, it really is a distressed play. And that's kind of what led me to this place, is that, I started to do some bankruptcy litigation. I have some friends who work for some of the big distressed funds who are doing a lot of bankruptcy litigation where they're buying up debt, they're asserting their kind of rights through the bankruptcy proceedings, and kind of recovering. Hopefully, you buy it for a cent, you recover 5 cents on your 1 cent, you're making a huge return. And as I kind of saw as I spoke to different managers who are in different types of industries, I kind of saw the same play in real estate, and I didn't necessarily see anyone kind of employing a less aggressive takeover and sell strategy and more of a takeover and hold strategy. And that really is what drove me to kind of look more into this and start to really formulate a pitch and formulate a way to talk to clients to say, hey, I get it. You don't want to do this to sell. You're in the business of, maybe you're a REIT, maybe whatever it is. You want to hold the property, you want rental income, you want some sort of appreciation on the asset. Why aren't you looking at a means to access? Why are you only just scouring real estate ads, talking to real estate agents, trying to make all of these phone calls? Great. Don't stop doing that, but just add to your list, subscription to one of these third-party services who, have the secondary loan market. Why not develop? You probably already have a very good relationship with your bank. Go to your bank. Ask them if they know other people in the industry. And all of a sudden now you're building the same sort of relationship, and it's a couple more phone calls. And the back end, could be, you could have much higher upside, and in certain jurisdictions, a much faster recovery of your investment if that's what you want.
Yeah, no, I'm listening, and as the wheels are kind of spinning or turning, I'm going, wow, this is genius, because it seems to me that the worst case scenario is that the borrower pays off the note, and you've already you acquired it at a discount, so you're making substantially more than what the originator uh, was expecting, or at least I guess it depends on how old the note is. Um, but if that's the worst possible outcome, that's pretty good. The best case is you end up foreclosing and are able to reposition and sell it at a significant upside. I'm curious, do you find that your clients do a lot of due diligence beforehand to make certain that there's a repositioning opportunity for the property if they do end up foreclosing?
Absolutely. Diligence is probably the most important thing, especially on a non-performing note. One, you want to make sure that if your end state is to foreclose and, exit, you want to make sure that it's not like they missed one payment and it just got put because the lender doesn't want to stomach the risk and they just don't want to deal with it. And it's a one-off. Conversely, if your strategy is to, hold assets, that may be great, right? It's like a bond. You can get into the bond at a discount, and now it's going to pay out, and everything's going to be hunky dory for the rest of the note. But yeah, diligence is super important. Where the market is, you need to really understand what the foreclosure proceedings are going to look like, so that you're eyes wide open. There are going to be states where you can do non-judicial foreclosures, which are going to go very, very quickly, and you can basically just go by notice. But if you're going to do it in New York City, there you need to file. You need to file a complaint. You have to litigate. You have to go through your statutes to make sure that all of your notices are squared away. So there are multi layers of diligence. You need to have diligence on the property itself. I always recommend you need to have diligence on both the bank to make sure they're in a good position and they're not just selling it because they're in a tough spot and it's actually the type of loan you want, which is a little easier if you have a relationship. Some diligence on the holder, because if the note holder is mismanaging or operationally is screwing up, then you may have other avenues, right? You may have other avenues to enter that property, to put in new management, and then to do a turnaround on it, and that may be even better than foreclosure. Um, and it also will tell you, if it's being funded through the operation of the business and the business is failing, they may be more willing to deal with you if you do purchase the note. So you don't have to go through foreclosure. You do a negotiated transfer. So they just transfer the property to you and you forgive part of it, or you take an equity position along with them and forgive a portion of the note, or forgive the note entirely, especially if it's an entity that's holding it. And then you all of a sudden have control interest in the entity. But yeah, really, this comes down to diligence, because the rest is, the litigation is difficult, and it's going to be, usually fairly aggressive, because, investors want their timeline, right? Nobody, if you want to turn around, you don't want to continue to stretch the timeline out. And if you're in a slow state, you definitely need to pursue and go about it. So the diligence on the litigation side is kind of more where we come in, and we advise you on, hey, this is the procedure. Here's what we're going to do. It's more the diligence on the actual real estate, and it's the bank, and it's the lending, and making sure it fits within your portfolio, and understanding what someone like me is really going to do for you, and really going to help you with. And if you're already holding properties, right, like if you're a note holder on certain properties as an investor, and you're having non-performance, or you're having performance issues, the nice thing about engaging with kind of litigation, even if we're not on the commercial real estate end, on litigation, you can also kind of clean some of that up, right? I do work with private equity who wants to clean up other lawsuits. It's the same with a portfolio of real estate. If you have non-performing aspects of it, can you clean it up in a way using litigation?
Yeah, no, it's Fascinating. I think the direction of all of it is gain control, and then you can plan your next move, kind of thing. It's interesting. Hey, Chris, if we could, I'd like to shift gears here for a second. By day, I'm an insurance broker, and as such, I work with my clients to assess risk and determine what to do with the risk. And there's three strategies we typically consider. We first look to see if there's a way we can avoid the risk. When that's not an option, we look to see if there's a way we can minimize the risk. And if we cannot avoid nor minimize, we look to see if there's a way we can transfer the risk. And as such, I like to ask my guests if they can look at their own situation. It could be your clients, the market, the interest rates, vacancies, whatever it is you identify and consider to be the biggest risk. And again, for clarification, while I'm an insurance broker, I'm not necessarily looking for an insurance-related answer. And so if you're willing, I'd like to ask you, Chris Zona, what is the biggest risk?
Sure. So I think it really fits within what we're talking about. I think the biggest risk for investors that are in this realm is that you need to be comfortable with taking over a potential non-performing note, right? Like there is no way to avoid risk when you're making this sort of play. So what you need to do is kind of, balance minimizing the risk through your diligence process, because you don't want to take on something that you're not ready to. You don't want to overextend in taking it on. And then kind of balance that with the, maximize your return on whatever risk, wherever in the risk matrix that you fall, right? They always say higher risk, higher return. Was very true. If you're going to buy a very, very non-performing loan, you're going to be, probably up on the tier of the extension of capital. And you need to mitigate whatever risk, make sure that you have a cap stack in place to do that. You don't want to take on additional debt in order to kind of engage in that strategy, because now you're becoming another note holder as well as being the enforcer. And then make sure that on the back end that you're prepared for whatever the downside of your investment is, and that your investors, if you're running a management, that you're openly communicating with them timeline and the potential downfall. As you said, the nice thing about this strategy is if you're not a very, very specific strategy fund or investor, you could minimize the downside by how you enter and what your exit looks like. If you're flexible in what your exit looks like, then this could be a very attractive strategy, because if you don't need to exit the property and return to your investors' capital within a short period of time, then maybe you can stay in that property longer, hope that the note holder turns it around.
Yeah, no, it's interesting and a lot to think about there. Very interesting. Hey, Chris, where can the listeners go if they'd like to learn more or connect with you?
Sure. So obviously I'm on LinkedIn just like everybody else. You can find me at Chris Zona. The Turning Conflict into Capital is published there. You can also find me at mblawfirm.com. That's Mandelbaum Barrett's law firm. I'm a partner there. And please feel free to reach out, especially through LinkedIn, because I have a lot of content on there on this and other subjects.
Awesome. Well, Chris Zona, I can't say thanks enough for taking the time to talk today. I've enjoyed it. I've learned a lot, and I look forward to doing it again soon.
Absolutely. Greatly appreciate the opportunity. I hope you have a great rest of your week.
All right. For our listeners, if you like this episode, don't forget to like, share, and subscribe. Remember, the more you know, the more you grow. That's all we've got this week. Until next time, thanks for listening to Commercial Real Estate Pro Network's CREPN Radio.
You're listening to CREPN Radio for influential commercial real estate professionals. For more information on this or any of our guests, like us on Facebook, CREPN Radio.